ask you about the three choices, and one thing in particular that this judge said that these jurors could do. He just delivered what is being called really the pinnacle of all of this. He said that there is no need to agree on what has occurred. They can disagree on what the crime was among the three choices. Thus, this means that they could split 4-4-4, and the judge would still treat them unanimously. What does that mean?
Yeah. Well, it's really outrageous because in a normal criminal case, every statutory crime has what we call elements of the offense. Like in a bank robbery case, it's, you have to rob, it's got to be a financial institution, you have to show intent. Those are the things the jury has to agree on unanimously that they were proved beyond a reasonable doubt. Here, what we're doing is taking the element that actually makes this a felony, because remember, falsification of records is normally a misdemeanor in New York. What makes it a felony is that you're concealing or committing another crime. And here the judge is telling them they don't have to agree about what the other crime is under circumstances where that not only is what makes this a felony, what makes it a 4-year potential prison penalty rather than a year or less, but it's also what gets us into the courtroom, because if this had been a misdemeanor, the time to bring this case would have lapsed in 2019. So the only reason they're still able to bring this case is because it's a felony, allegedly, and yet now the judge is saying, you don't have to agree on what the felony is.
Yeah, I was ready, they didn't have my back. They were petty, I stayed in my bed. On that petty, I brought it right back.
I really wish somebody would tell me what the crime is. What a sham, what a sham, what a sham. What a disgrace. Sent the jury to the Wendy's drive-thru to get a 4-for-4 with a strawberry lemonade. Oh boy. And you better not forget the barbecue sauce. And one of the jury said, give me honey mustard. God. Wait. Now that mega hat costs money. Don't ever disrespect my hat like that. We've already sent out 1,000 some of these hats to beautiful family members on the channel. Make sure y'all send me an email now. But I got a haircut today. That haircut cost about $100 in the Biden economics plus taxes. I almost paid $200. So I'm gonna take the hat off this video, y'all, because boy, I was outside cutting the grass. When y'all was sending me the news, the articles, I said, oh man, this is funny to get good, y'all. I was out there cutting the grass. Yeah, man, out there sweating, rolling that lawnmower through the grass, man. I tell you, I got one of them push ones, so you really got to work hard out there. Yeah, boy, I thought it was 19. Y'all know I'm gonna give y'all a good old time, man. Y'all relax, man. Take a joke, okay? Some of y'all say, Rick, you're not funny. I know. But all jokes aside, you guys, let's jump straight in and salute to my brother Nez. He loves our channel as well. Make sure y'all check him out in the description box down below. But again, y'all, this is just a waste of time, energy. This shouldn't even been bought, man. Taxpaying dollars just flying out in the breeze. For real, you guys. People are laughing. The kangaroo, we didn't even know the kangaroo could jump that high. Is he over there peeling a banana in the Republic? Oh, man. We just didn't know, y'all. We're living in some dark, dark times, man. But let's get into this update. And and after this video, we're gonna be sending out tons of you guys mega hats. Today I've been slacking because I true story, I was really outside cutting the grass, and then my edger, I was trying to get my string in there because I had to restring it, and I done tore the thing up. So I'm out there with the lawnmower trying to edge up my grass with the lawnmower. Don't laugh at me now. I know some of y'all cut y'all grass because I be making jokes about it, but my grass was high as out there. I'm telling y'all, man, like it was high. Like, boy, it was a jungle out there. I'm telling you. And I was out there like a true patriot, sweat dripping down my back, pushing that lawnmower through there. True story, man. And then I said, you know what? I need to go get a haircut, man. My Patriots is right. I look terrible. Yeah, when I came in and looked at myself in the mirror and I was sweating, I said, I look terrible. I got to go get a haircut. And that haircut cost about $300. So I ain't wearing my hat this video, y'all. I'm going to let my haircut shine, all right? As we go through this update. But shout out to my brother Nez and Nez Nation, man. Make sure y'all go check him out in the description box down below. Let's jump straight into this huge update.
Thank you very much. I would say, in listening to the charges from the judge, who's, as you know, very conflicted and corrupt, because of the confliction, very, very corrupt. Mother Teresa could not beat these charges.
Mother Teresa can't beat these charges. Man. I almost said something, but I gotta watch my words on here, y'all. Y'all know I gotta watch my words.
Has been sent to deliberate. Just wait till you hear what Judge Merchan's instructions to the jury were. You might not even be shocked. You might not even be mind blown, but I tell you this, it's something that nobody in the history of the criminal justice system could have ever foresaw happening in this day and age. The Trump trial in New York City, the sham trial that every single legal scholar, legal expert, legal specialist, legal law professor of any worth has noted there is no merit here, there's no grounds here, has ended. It's over. Closing arguments are over, which, by the way, if you missed my video yesterday, the prosecution went over 5 hours.
5 hours.
And basically conducted a filibuster. Meanwhile, the defense attorney, Todd Blanche, he was done in just a couple of hours. Efficient, to the point,
on point,
direct, conclusive, evidentiary, and substantive. Those are superlatives that have been hurled upon Todd Blanche from every single legal scholar and legal expert in the country. Here is the complete breakdown of how unprecedented Merchan's novel theory, complete out of left field theory of criminal liability is. Now, normally in a criminal trial, the constitutional requirement is that a jury reaches a unanimous verdict on guilt or innocence. Unanimity requires that all the jurors believe the burden of proof. Remember, the burden of proof is not on the defense, it's on the prosecution. It has to be beyond a reasonable doubt, and has been satisfied on every element of the alleged crime, which we still have no clue what the alleged crime are, what the 34 counts entail. There is no crime. There is no victim. There's nothing to pin Trump on. Implicit in this scheme is that there's also unanimity on what the underlying crime is.
Wasted everybody's time and good energy, man. For real. Complete sham, y'all. This is what we've gotten to. This is sad, man. I don't mean to eject, but boy. I'm telling y'all, man, that grease is boiling and that grease is hot. That fish grease is hot, man. Remember y'all throw that fish in that cornmeal and get that grease hot? It's hot right now, man. But like I tell you, this it's actually worked in his favor. It's made him more popular. It's woken a lot of people up, man. And I know a lot of y'all saying, Rick, we don't care which way it goes. It's Trump 2024, baby. He'll do a better job even if he's I gotta watch my words on here, but yeah.
You can't have one juror believing the burden of proof was met by one crime and another juror believing the burden of proof was reached from another, but not the first crime. And because both jurors believe the defendant was guilty for quote unquote something, that fact alone should drive a guilty verdict. That would be an absolute violation of due process. It implicates double jeopardy issues, and it completely destroys the high evidentiary standard needed to prove guilt in a criminal trial. But apparently for Merchan, none of that matters. If juror one, so this is what this means. If juror one believes the people did not meet its burden of proof for the FEC violation, but did on some nebulous tax law evasion violation, while juror 2 believes the opposite, the fact that they both were in consensus on a guilty verdict, I can't believe I'm saying this, but according to Mershon, is actually sufficient for a guilty verdict. Here's what I mean. Mershon says if there was a conspiracy to affect the outcome of an election, jury can consider whether the defendant violated the following laws. Number 1, Federal Employees Compensation Act, FECA. Number 2, falsification of business records. Or number 3, tax laws. I mean, this is like the broadest definition of a crime in history. Mershon is literally throwing the entire book at the jury. What authority does he have as a state court judge from a mediocre law school to opine on something as nuanced as federal election law? He's the fake Don Juan Mershon. It's so egregious. It's so rigged. It's not even funny, Des Nation. And it's so intricate, FEC law, and complex that the FEC has exclusive jurisdiction and ordinarily preempts other courts from all federal election law related issues. So this is beyond utterly outrageous. Mershon is deliberately, this is an actual concerted, premeditated, self-interest based proceeding. Mershon is deliberately lowering the threshold for what Bragg needs to prove in order to more easily reach a guilty verdict. It's the coup de grace for Mershon. That means it could be a 4-4-4 split.
Told y'all, sent them to, here, y'all go through that Wendy's drive through here. I'll pay for it. And y'all get whatever y'all want. But I advise y'all to get the 4 for $4. It's a little cheaper, and you get, burger, nuggets, and fries. And you get sauce, and you get a drink. Strawberry lemonade, barbecue sauce. Unbelievable.
They don't have to unanimously agree on what the actual crime is, but they do have to unanimously agree that is either guilty or innocent. It's nuts. Paul Ingrassia, who was reporting from the actual courtroom, said this. He said Mershon was speaking when he was giving jury instructions to the jury. Mershon was speaking in very quiet voice, mumbling at times, speed reading through the jury instructions. Very difficult to hear. Why were you doing that, Judge Mershon? Why were you acting so coy? Notably, though, Paul Ingrassia says, his voice gets slightly louder when he talks about a, quote, guilty, end quote, verdict. And his voice quiets to a near whisper when he says, quote, not guilty, end quote. His enunciation, his tone, cadence, volume is left much to be desired. And I think, in my humble opinion, shows a clear-cut evidence of bias. 1 billion %. What do you guys think? I want to hear what you guys think in the comments. I can't wait to read your comments on this. So what this means is, number 1, 4 jurors could agree on the first crime. Let's say it's falsifying records. 4 could also disagree with that, but agree on the second quote-unquote crime, tax violations. And yet another third 4 could agree on federal election violations. And Judge Mershon would still count that as a unanimous guilty verdict from 12-member jury. This is, you can't even say rigged. You can't even say the fix. It is so absurd with a capital A.
I'm at a loss for words, man. I really am, y'all. I don't know how many times I didn't. Just wasted all of my beautiful Patriots' time. Just for what? Why? We shouldn't even be going through this, man. This video we shouldn't even be making a video about none of this, man. Shouldn't even exist.
Well, let me ask you about the 3 choices. And one thing in particular that this judge said that these jurors could do. He just delivered what is being called really the pinnacle of all of this. He said that there is no need to agree on what has occurred. They can disagree on what the crime was among the three choices. Thus, this means that they could split 4-4-4 and the judge would still treat them unanimously. What does that mean?
Yeah. Well, it's really outrageous because in a normal criminal case, every statutory crime has what we call elements of the offense. Like in a bank robbery case, it's, you have to rob, it's got to be a financial institution, you have to show intent. Those are the things the jury has to agree on unanimously that they were proved beyond a reasonable doubt. Here, what we're doing is taking the element that actually makes this a felony, because remember, falsification of records is normally a misdemeanor in New York. What makes it a felony is that you're concealing or committing another crime. And here the judge is telling them they don't have to agree about what the other crime is under circumstances where that not only is what makes this a felony, what makes it a 4-year potential prison penalty rather than a year or less, but it's also what gets us into the courtroom, because if this had been a misdemeanor, the time to bring this case would have lapsed in 2019. So the only reason they're still able to bring this case is because it's a felony, allegedly, and yet now...
Allegedly. This is ridiculous, man. I can't, y'all. This is a disgrace, man. Y'all comment down below what y'all think, though, man. Comment down below, you guys. It's still Trump 2024, man. And we're going to crack open a cold one in November. We still in this truck riding down the interstate. Check engine light is on. The check engine light is on. We still ride. Bless you all and your families. We are sending out more Make It hats today. If I haven't emailed you back, I do apologize. We're going to be emailing a lot of you guys back today. We're going to get back on track today. I had a lot going on. Like I said, I was out there cutting the grass, getting a lot of things done, and finally got me a haircut. But God bless you all again. Y'all spread the love. We are living in some dark, dark times, man. Dark, dark times. Comment down below what y'all think of this. And hey, I will catch you beautiful people in the next one.